If your joint account holder dies without a will, this rule decides what happens. Millions of people open joint bank accounts every year with a spouse, a parent, a business partner, or a sibling. It feels simple, it feels safe. Two names on one account, so if something happens, the money is protected. But here's the question almost nobody asks until it's too late. What actually happens to a joint account when one holder dies and there is no will? Most people assume the surviving account holder automatically owns everything. Some assume the bank freezes the account immediately. Some assume the family has to go to court no matter what. The truth is more specific than any of these assumptions, and it depends entirely on one legal rule that most account holders have never read: the survivorship clause. Let's break this down properly. No confusion, no guesswork, just the actual rule that governs this situation. When two or more people open a joint bank account, the account typically operates under what is called either or survivor or former or survivor. Turkey, these are standard mandates offered by banks. Under this arrangement, if one account holder dies, the surviving holder gets operational access to the account balance. This is not because the deceased person's share magically disappears. It is because banks are legally permitted to release funds to the surviving holder based on the mandate the account was opened with. This is the single most important fact in this entire topic. The bank's rule of survivorship determines who can access the money, but it does not automatically determine legal ownership of that money. These are two different things, and confusing them is where most families get into trouble. Here is the distinction that almost nobody explains clearly enough. Access means the bank allows the surviving holder to withdraw, transfer, or operate the account. This happens quickly, often just by submitting a death certificate and a few standard forms. Ownership, on the other hand, is a legal matter. It is governed by succession law, not banking policy. If the deceased person did not leave a will, the money in that account, to the extent it belonged to the deceased, becomes part of their estate, and it must be distributed according to the laws of intestate succession that apply in their jurisdiction and personal law. In simple terms, the bank will hand the money to the survivor, but legally, that money may not belong only to the survivor. If other legal heirs exist, children, parents, siblings, or others, depending on the succession law that applies, they may have a legitimate claim to a portion of those funds, even though their name was never on the account. Banks are not in the business of resolving family inheritance disputes. Their job is to ensure operational continuity, meaning the account doesn't get frozen indefinitely while paperwork is sorted out. The survivorship rule exists purely for administrative convenience. It allows the surviving holder to pay bills, manage funds, and avoid the account becoming inactive or locked. But the law draws a clear line. Banking convenience does not override inheritance law. This is why, in many jurisdictions, courts have repeatedly ruled that a survivor who receives funds under a joint account mandate is technically holding those funds as a trustee for all rightful legal heirs, unless it can be proven that the money was intended as a gift solely to the survivor. Since ownership depends on the deceased person's share of the account, the next logical question is, how is that share calculated? This depends on how the account was funded and maintained. If both parties contributed equally, the deceased's share is typically considered to be 50% of the balance, and that 50% becomes part of their estate. If only one party contributed the funds, for example, a parent added a child's name only for convenience, without the child ever depositing money, courts often treat the entire balance as belonging to the original contributor's estate, regardless of joint status. If contribution records are unclear, which is extremely common, the determination becomes a matter of evidence. Salary slips, deposit history, source of funds, and the intent behind adding a joint holder. This is precisely why financial and legal experts recommend maintaining clear records of who contributes what to a joint account, especially when the account involves parents and adult children or business partners. When there is no will, the process generally unfolds like this. First, immediate access continues. The surviving holder can usually continue operating the account under the survivorship mandate once the bank is notified of the death and a death certificate is submitted. Second, the estate is identified. The deceased person's share of the account becomes part of their overall estate, combined with any other property, investments, or assets they owned individually. Third, legal heirs are determined. Since there is no will, the applicable law of intestate succession decides who the legal heirs are. This varies significantly depending on personal law, religion, and jurisdiction, but generally includes a defined hierarchy, usually spouse, children, and parents, followed by more distant relatives if none of the above exist. Fourth, a succession certificate or legal heir certificate may be required if other heirs wish to formally claim their share, or if a dispute arises, they typically need to obtain a succession certificate or equivalent legal document from a competent court, which legally establishes who is entitled to inherit the deceased's assets. Fifth, distribution or dispute resolution follows. If all heirs agree informally, the survivor may simply retain and manage the funds with the understanding of shared entitlement. If there is disagreement, the matter can go to civil court, where the succession certificate and evidence of contribution will determine the final division. The most damaging misunderstanding is this. People believe that being named as a joint holder is the same as being named as a nominee or beneficiary. It is not. A nominee is simply a trustee for receiving funds on behalf of legal heirs. Nomination does not confer ownership. A joint holder, especially under an either-or survivor mandate, does get operational access, but as explained earlier, that access does not equal full legal ownership either, unless the funds were solely contributed by that person or clearly intended as a gift. This misunderstanding is the root cause of countless family disputes after a death. One sibling assumes the joint account automatically belongs to them, while other siblings assume they are entitled to an equal share of the estate, including that account balance. If the deceased had written a valid will, none of this ambiguity would exist. A will allows a person to clearly state how their share of a joint account and all other assets should be distributed after death, regardless of who is named on the account. Without a will, the distribution is left entirely to statutory succession law, which does not consider personal wishes, family relationships, or informal agreements. It applies a fixed legal formula. This is why financial advisors and estate planning professionals consistently emphasize one point: joint accounts are a convenience tool, not an estate planning tool. Relying on joint holding alone, without a will, creates legal uncertainty, even if the family relationship is close and trusting. For anyone managing a joint account, a few precautions can prevent significant legal complications later. Clearly document who contributes to the account and in what proportion. Understand the difference between either or survivor and former or survivor mandates, since they affect access differently. Add a nominee to the account in addition to joint holding, since nomination and survivorship serve different legal purposes. Most importantly, create a legally valid will that explicitly addresses how joint account funds should be treated after death. If a joint account holder dies without a will, the surviving holder typically gains immediate access to the funds through the bank's survivorship rule. But that access does not automatically mean full legal ownership. The deceased's share of the account becomes part of their estate and is subject to the applicable laws of intestate succession, which determine the rightful legal heirs. Understanding this distinction between operational access and legal entitlement is essential for anyone who shares a joint account with a family member, spouse, or business partner. It is not a matter of assumption, it is a matter of law, and the outcome depends entirely on documentation, contribution history, and whether a valid will exists. The safest approach is not to rely on survivorship rules alone, but to combine joint holding, nomination, and a clearly written will, ensuring that when the unexpected happens, the outcome reflects clear legal intent rather than confusion, assumption, or dispute.